India has refused to allow access to minutes of meetings held to take a decision on the issue of demonetization. Responding to an RTI application, the RBI has refused to divulge the details of meetings of Central Board of Directors on the issue of demonetization. In fact, the central bank has cited Section 81A of the Transparency Law. The section exempts disclosure of information which would prejudicially affect the sovereignty, security and integrity of India.
Well, we have with us the man who filed that RTI application with the Reserve Bank of India as well as the Department of Economic Affairs, Mr. Venkatesh Nayak, who's the RTI activist. He's also the coordinator of Access to Justice program. Sir, many thanks for joining us. It's good to have you on India Business Hour. Let me first start by asking you this. What were the details that you were seeking? What prompted you to file this RTI?
Well, you see, first of all, the decision to demonetize high-value currency and then the decision taken to remonetize the economy are going to go down in history as a major landmark decision, irrespective of the merits or demerits of the issue. So this is a decision that affected every single citizen, every person living within India. The Right to Information Act says that whenever such important policy decisions are announced, the government has a statutory obligation to make all facts public. The notification that was issued on 8th November and subsequent notifications do not contain the details of the decision-making process. They do not contain the materials on the basis of which these decisions were made. That's the reason why I filed an RTI application with the Department of Economic Affairs, primarily asking for the cabinet note that was submitted to the Union Cabinet for approving this decision of demonetization, and all the materials that went into the process of decision making as far as demonetization is concerned. As far as RBI is concerned, I filed another RTI application asking for a copy of the minutes of the board meetings that were held prior to this decision and all subsequent meetings of the board on the issue of demonetization until the date of the application, which is about 14th November. In addition to that, what I read in the newspapers at that point of time was that there was a report of some think tanks that apparently made some submissions and recommendations to the government, including on the issue of demonetization. However, the media reported that the think tank had said that the methodology of demonetization that the government has been following now was not what they had recommended. So there is an immense amount of public interest to know what exactly were these proposals that were submitted by think tanks to the Government of India and what was the Government of India's reaction on that, and all file notings relating to this decision-making process. So these were the RTI applications that I had submitted on the 14th of November, first one to the Department of Economic Affairs and the second one to the RBI.
Okay, Mr. Nayak, in both the cases, for instance, the CPIO, in the case of the DEA, they invoke Section 7(9), saying that the information cannot be provided as it would lead to disproportionate diversion of resources of the organization. I'm quoting it. And in the case of the RBI, they quoted Section 81A, and that relates to several areas like sovereignty, threat to India's integrity, security, scientific, economic, defense interests of the country. Do you believe that this falls under these sections? That do you believe that the information actually falls under this, or is this unlawful to actually deny it under these specific grounds?
Well, see, first of all, let me clarify. The Department of Economic Affairs did not even bother to respond to my RTI application. More than 40 days have passed and now I filed a first appeal with them. There was simply no response at all from the CPIO, so we don't know what the DEA is thinking on my RTI application. Section 81A and 79 both were invoked by the RBI CPIO. Regarding the cabinet note, regarding the minutes of the board meeting of RBI, the CPIO invoked Section 81A in toto, and that is extremely worrisome because Section 81A contains 8 grounds for refusing access to information, sovereignty integrity being one, security interest being another, economic interest of the state being another. It also included relationships with foreign countries, and very surprisingly, 81A also contains use of information for the purpose of committing any offense. Now, does the CPIO imply that I would use the information to commit an offense in India? That's completely ridiculous. If you look at the RBI's website, the minutes of the meeting of the Committee on Monetary Policy is proactively disclosed on that website. Surely the demonetization decision falls in the same category of landmark decisions that the government takes in order to manage the economy. And the minutes of the RBI's board should have been, the board's meeting should have been proactively disclosed. That was not done. That's point number one. Point number two, regarding my request for information about what recommendations came from various think tanks and policy advocacy institutions, RBI said that the form in which you want, which is I basically wanted photocopies, they said giving information in that form would disproportionately divert the resources of their organization. But they did not tell me in what other form they could give me the information. Under section 7(1) of the RTI Act, it is not permissible under 7(9) to deny access to information at all. It is an enabling provision to provide access to information to people in the form that they want ordinarily, but if it leads to disproportionate diversion of resources, then some other form of providing access must be provided. And that is very clear in the case law that has developed over the last 11 years in India. Unfortunately, the CPIO of RBI has not paid attention to that. Instead, he has rather illegitimately and also unlawfully invoked 7(9) for rejecting access to that information also, which is not permissible, and I'm planning to challenge that through a first appeal later this week.
I was exactly coming to that, Mr. Nayak. So 8(1) takes care of several issues like territorial integrity, strategic, scientific, economic security and defense interests of the state, relations with foreign states, and incitement to an offense. These are the circumstances under which 8(1)A can typically be invoked. It has been invoked in the case of your RTI. Now, you must have spoken to your lawyers. What are the legal options that you have? What are you planning to explore?
Well, frankly, because the way in which the Right to Information Act has been crafted, any sensitive and reasonably intelligent citizen can actually file the first appeals without the need for any lawyer. Lawyers would be required when we go to court against the decision of refusal eventually after exhausting all options under the RTI Act. So what I am planning to show, in my first appeal is that the harm test that section 8(1)A requires the CPIO to apply, which is to explain which of the 8 grounds under the RTI Act are applicable. Is it economic interest? Is it strategic interest? Is it security interest of the state? Which is applicable? That is not clear. So the RBI CPIO has a duty to clarify which of these interests is applicable to the information I sought. And that's not all. The CPIO also has to explain how any of these protected interests would be adversely affected by disclosing the information. None of that explanation is given in the
Mr. Nayak,
CPIO, which I think I'm entitled to.
Mr. Nayak, I get your point. You mentioned that you're planning to move court in a week's time. How does it work? So which is the first?
I will be, actually within the RTI Act, within the scheme of the Right to Information Act, the first appeal against the CPIO's decision lies with an officer who is senior in rank to the CPIO in the RBI. So I will be filing it with the first appellate authority. And if the first appellate authority agrees with the CPIO's decision not to disclose, then my next step under the RTI Act would be to appeal that decision before the Central Information Commission. If the Central Information Commission also agrees with the decision of refusal, then I would certainly consult my lawyers about filing a writ petition before the appropriate High Court, challenging the decision of rejection of access to information.
Okay,
so
fair enough, but that's the case of the RBI. Correct. So that's as far as the 8(1)A issue of seeking the details of the board meeting in the minutes of the board meeting with the RBI is concerned. But your application to the DEA was seeking the cabinet note that was submitted. What are you planning to do as far as the DEA is concerned? Because if in 40 days a notice does not come in, details do not come in, it is considered as a rejection. So are you planning to pursue and take up the issue with DEA as well?
Yes, of course. I have, like I said earlier, I have already filed a first appeal with the first appellate authority of DEA as well, because that is the logical step under section 7(2) of the RTI Act. And if the DEA does not respond to the first appeal, either they have about 45 days under the law to give me a decision, or if they say that the information cannot be provided, then I would still be going to the Central Information Commission against the DEA demanding disclosure, because this is a set of information that is of immense public interest. If you remember some time ago, before the Supreme Court of India referred this matter, rather recommended to the Chief Justice to refer this demonetization issue, a batch of petitions to the Constitutional Bench, they asked the Honorable Attorney General of India whether he is willing to produce the cabinet note before them in that matter. The media hasn't reported what the AGI's response was, but even the court believes that in this kind of a situation, disclosure of the cabinet note is of paramount importance. That's the reason why they raise this question. And the RTI provides for disclosure of cabinet notes once a decision is taken and the matter is completed and over. As far as demonetization is concerned, in my humble opinion, the decision has been taken, the demonetization decision is being implemented, so the matter stands complete and over, and there should be no bar on the disclosure of the cabinet note and the file notings related to it. I do not understand why the DEA has not even bothered to send a response in this case.
All right, Mr. Venkatesh Nayak, it's a pleasure to have you on the show, and thanks for taking us through your application and the road forward. We hope to have you back when there is